both parties ready on Harris versus Soha?
The appellant is ready, Your Honor.
Proceed whenever you're ready.
May it please the Court, I'm William Ball. I represent the appellant, Lana Harris, who is the personal representative of the estate of her late husband, Richard Harris. And I advise the Clerk I'd like to reserve 4 minutes for rebuttal. There are basically two issues, as the Court knows from the briefs in this case. The judge first ruled that subsection 2C1 of the Good Samaritan statute applied to this case, and he ruled it as a matter of law. We contend that that was error. He second, then, having determined that that was a standard, that is, that we had to prove willful and wanton conduct on the part of Dr. Soha, he then ruled that our evidence did not make a jury case under that standard. We disagree with that ruling as well. I'll address the first one, the first argument first. There are basically three elements that must exist for this affirmative defense to apply. Two of them really relate to the type of practice the doctor has and why he's going to see the patient. The evidence was that there was an established practice in this hospital by which physicians in the emergency room could call either the OR or the obstetrical suite for assistance from an anesthesiologist. Testimony was that...
Let me ask you a question.
Certainly.
Not to interrupt, but we do have a fairly good grasp of the facts.
Okay.
So basically, on your first point, we're construing the statute, and I know you break with the statute at several different points.
Right.
Let's start with the first point, which is a patient in his or her practice.
Right.
So we always like to look at where these things are going.
All right.
Let me ask you a specific question. Would you agree that under your construction of this defendant, I believe, is an anesthesiologist?
Yes.
Let's make this defendant a pathologist with a hospital practice.
Right.
Under your construction, would you agree that a pathologist would never then have the benefit of this statute?
Yes. I believe this, and here's the reason. I don't think the statute is intended to apply to hospital-based physicians, part of whose ordinary duties is to render services to other doctors' patients in the hospital. And bear in mind, this is a very, very high standard. It comes close to granting an immunity, at least under some interpretations of it. And it is in derogation of the common law, and it does impact the right of patients to have their day in court. And it ought to be construed narrowly. So, yes, I believe it does not apply to hospital-based physicians, either anesthesiologists or pathologists. The other element, which at least should have been a jury question in this case that I'd like to talk about, is whether this response was voluntary. Now, we conceded in pretrial hearings and so on.
Let me ask one more question about the first part of the statute, because the second part may have some factual, may or may not have some factual issues. On the first part, are there any factual issues that would preclude us from construing that part of the statute the way you say it should be construed?
No, I think the trial judge could have ruled on that as a matter of law, and I think this court could as well. On the voluntariness issue, I think that's a classic jury issue. There was no call list. There was no quote-unquote legal obligation to see this patient. But there was an established procedure by which the doctors in the emergency room knew they could get assistance from an anesthesiologist, even to the extent of calling someone who was at home. This was Dr. Augustine's testimony. If the anesthesiologist was on call to the operating room, they knew how to call somebody who was at home. And you need anesthesiologists in a hospital emergency room. So I think the jury could have found that Dr. Soha, while not acting under legal compulsion, was not acting voluntarily. We all know the sort of joke about the military movies where the officer lines up his men and says, who would like to volunteer to go clean the latrines? Well, they know if somebody doesn't do it, somebody's going to be designated. And I think the jury could have found that Dr. Soha knew that there could have been some repercussions if he had said, no, I'm not going to the emergency room the way other anesthesiologists, the testimony was, had done. The third point, I'll make it very quickly. I can't base it on a construction of the statute because it says if it's an emergency, that portion of the statute applies. It was an emergency. But I would just suggest that it stands the statute on its head to say that a doctor who takes his time and who himself does not treat this patient as an emergency patient gets the protection of the statute because there was an emergency. As the court knows, it took him 15 to 20 minutes to go down 3 flights of elevators to see this patient. If the patient had died during those 15 to 20 minutes, he would still be arguing that because he needed to come soon, he was entitled to the willful and wanton standard. It simply doesn't make sense.
If he was under no legal obligation to come, how can he be liable for the amount of time it took him to get there?
Well, once he says, and this was testimony we asked our expert with, and it was an issue in the case of whether there was a doctor-patient relationship. Our expert says, once you say, I'm coming, you have become a consultant. You have a duty to that patient. You can't say, I'm coming. And he was told it was an emergency, Your Honor. He was told by Dr. Augustine, it's in the record. You can't say, I'm coming to see your emergency patient, and then take 15 to 20 minutes. Maybe you can say I'm not coming, but you can't say I'm coming because that leads Dr. Augustine to think help is on its way. He's not going to call anybody else. No other anesthesiologist is going to be asked to help this patient. But let me talk about the evidence and what the standard is, even if we apply willful and wanton.
Well, counsel, I'd like to go back just a second on the voluntary point, because it seems to me you were saying that, first of all, there seems to be a definitional issue. What does voluntary mean under the statute? Does it mean that there's no legal compulsion? And secondly, if that's the case, are your facts sufficient? If in fact there is a, quote, informal hospital practice, is that sufficient to be compulsory?
If the statute means no legal compulsion, we would lose on that issue. But the statute should not be construed that way because the statute is in derogation of common law and it limits patients' rights to access to the courts. So the word voluntary ought to be given a construction in our favor, and there are different constructions that could be put on.
Okay, yeah, well, give me a couple of those constructions. If we're not talking about legal compulsion, what should the test be?
Whether the Good Samaritan was someone who, out of feeling for the person by the side of the road, went to help. This is a doctor it would apply to a doctor who, because he cares for patients, does something that there's absolutely no pressure on him to do. It's not limited to legal compulsion.
Okay, but I'm still not sure you give me a definition or a test to be applied. That's what I'm looking for.
Well, I think it's a jury question. Was he going there because he wanted to help the patient, or was he going there because he knew that he's an anesthesiologist and he's supposed to be down there helping, and if he didn't go, somebody might question it.
Okay, if it becomes a jury test, though, how are we to instruct the jury?
Well,
the question of voluntary. I mean, if I was a trial lawyer, I'd want to be in a case, I'd want to be able to make the argument and know what I'm arguing. So I guess that's where I'm coming from. I need to figure out what is an alternative, a workable alternative for the trial courts to deal with.
Well, I would deem voluntary as something that is motivated or is complete, that the doctor can make completely on his own decision. There are no outside forces, whether legal or by practice, acting on him. That's how I would define it. That's the best I can do. I want to talk very much about the evidence that proves this was a jury question on willful and wanton. This is what the trial court said, and this is what was quoted in the appellee's brief. Willful and wanton means highly unreasonable conduct involving an extreme departure from ordinary care in a situation where a high degree of danger is imminent. Our expert testified, first of all, whether it was highly unreasonable. His words were preposterous and inexplicable. And if those don't make a jury case on what's highly unreasonable, I don't know what does. The next element is a high degree of danger. Our expert testified that this man who was sitting, smiling, talking, not talking, but non-verbally communicating, he's on the razor's edge of dying, and he had a 90%, according to our expert, and this testimony has got to be believed for directed verdict purposes, a 90% chance of dying unless he's in debate, and that a reasonable anesthesiologist should have known that fact. So we met the high degree of danger. Was it apparent? Yes. Again, he testified that that would be known. It's something that a competent board anesthesiologist would know. And essentially, what his testimony can be summed up as, excuse me, let me find the portion of his testimony I wanted to read to the court. Basically, he says that the angioedema is progressing, that the anesthesiologist should have known it, and if he obstructs, the anesthesiologist should have known that he would obstruct, and if he obstructs, he will die.
Is this the same degree of wrongdoing in the context of this statute as would support punitive damages?
I don't think it is, because we now have a statute that lays out a whole list of requirements for punitive damages. The court may be aware it's in another portion of 768. Under the old common law, willful and wanton, it's close. I don't think it's quite there. I mean, again, it's the definition. I think I will agree with the definition that it's highly unreasonable conduct involving extreme departure from ordinary care in a situation where a high degree of danger is apparent.
Hasn't our Supreme Court said many years ago that common law of Florida, the degree, if you're going on negligence, a degree of negligence, I certainly agree that this is on the spectrum of negligence, less than unintentional. But hasn't our court said many years ago that it is the type of action that would support the criminal charge of manslaughter?
It has. It's also equated it to reckless disregard. It's very hard to tell. And I want to point out, and I know I'm over my time, but I want to say one more thing. All of this I've said so far assumes that the only conclusion the jury could reach is that Dr. Soha went to the emergency room intending to help if he could. And I think the jury did not have to reach that conclusion. He went to change his clothes. He testified he didn't take the most direct route, even though he works in the hospital and is down one flight, is down the same elevator bank. He denied repeatedly in his deposition that he had any duty to this patient. He didn't examine him. He didn't take a history. He asked to leave the minute he had spent this.
But under your construction, though, it seems that the physician would always have to know the nature of the emergency before he or she arrived on the scene.
I don't think so. If the doctor says it's well, first of all, he did. He was told that there was a patient with angioedema and that the ER doctor needed help with the airway. He knew it was an airway problem.
That was conveyed to anesthesiology?
Yes.
Part of the page?
Yes. Yes. He was told that. So he takes all that time to get down there, asks to leave immediately, doesn't leave, but then he walks out on the patient before the EMTs even come in. And that's when the patient obstructs. Now, I think you can put all that together with his repeated denials of any responsibility to this patient and decide that he was basically covering himself so that nobody could say you didn't respond, but he didn't go down there to help this patient. That's what the jury could have found in this evidence. And if that isn't willful and wanton, I don't know what is.
Thank you.
May it please the court, my name is Gary Shipman. I'm with the firm of Dunlap and Shipman, and I represent Dr. Soha in North Florida Anesthesia. I'd like to first start out by addressing the portion of the statute regarding that was objected to by appellant regarding volunteering, whether Dr. Soha was a volunteer. What the actual testimony is that anesthesia is not one called for the emergency room. Both ER physicians testified to that. So did Dr. Soha. So did the operating room administrator.
Mr. Shipman, help me. If we construe the statute that there has to be legal compulsion to attend to that patient, aren't we opening it up for the hospital to say to all their physicians, all their specialists, that nobody is directly on call? It is, you come, we call. It's your choice. Winking, the wink of the eye. You're going to come, but we're going to make it voluntary so you can't get in trouble. I I mean,
I think what's happening today in hospitals, like in this particular hospital, the specialists themselves, the hospital, to get them to come, have to negotiate a contract. In the case of our contract, it was exclusively for the obstetrical suite and the operating room. The hospital was certainly free to hire its own in-house anesthesiologist or CRNA to put them on call, just like in this particular hospital, ear, nose, and throat doctors refused to take call on weekends, which is what the problem really was in the first place here, that there was no ENT available in this hospital because it was a Saturday, and that's what the patient needed.
but, you know, this kind of bothers me, you know, if I go to the hospital, an emergency room, I'm gonna hope that there are gonna be people, you know, specialists on call if I need it. So aren't we allowing hospitals to kind of have false pretenses? You don't want to have specialists on call, don't have an emergency.
I think the problem there is if the hospital wants to have them, the hospital needs to contract with them to be there, which means the hospital needs to pay. You're concerned about if you go to the emergency room and you need a particular doctor and they're not on call, you want them to help you anyway. And that's why the legislature enacted this statute, so that doctors who have no legal duty otherwise, and I think there's no question here, there was no legal duty. Dr. Soha, their own expert, Dr. Murphy, said that. In fact, Mr. Ball agreed with the trial judge in the pretrial when asked a direct question about it, that he had no legal duty to go down to that emergency room. So if you have no legal duty, then the question becomes, are doctors, on the whole reason the legislature enacted the statute was because of the litigious society that we've become, doctors have become afraid to volunteer to help because they don't want to get sued. In fact, that's documented in the legislature documented the statute itself under subsection C3, where they say the purpose of this paragraph, it's the legislature's intent to encourage healthcare practitioners to provide necessary emergency care to all persons without fear of litigation.
Why should that extend, though, to a staff physician who's in the hospital for his own business purposes with the hospital, not attending some other purpose, who responds to a page, as opposed to who stumbles upon an emergency situation such as a slip and fall?
Well, first of all, he's not a staff physician. Staff physician meaning he's employed by the hospital. He is not. He is a hospital-based physician in the sense that his practice.
You explained that, right?
Yeah, that his practice attends exclusively to patients in the hospital. The hospital could have contracted, I suppose, to require him to cover.
Well, you're right. You changed my question, Mr. Shipman, to a staff physician whose contract does limit him to specific areas, in this case, OB and operating. Why should we extend the statute to extend to that person who's acting like a doctor in the hospital, as opposed to someone that we would traditionally think of as a good Samaritan who is simply acting as a volunteer?
I think the legislature, at least the intent, I believe they expressed in the statute, because if you read what they say a physician in the hospital treating a patient in his practice, and I disagree with the definition of practice. I frankly have never heard that a physician can only practice in his office.
He's doing it. Your client was doing anesthesiology pursuant to his contract. That's enough for him.
And that was his practice. But it also goes on to say, our business purposes, our personal reasons unrelated to patient care. I believe this legislature, and then when you read subsection C3, where they're trying to encourage health care practitioners to provide emergency care to all persons without fear of litigation, that the intent of the legislature was to cover any doctor who didn't have a legal duty to respond to an emergency.
I guess what I'm suggesting, though, is that those second two, there's a series of exceptions there. The second two seem to adhere to the more traditional notions of Good Samaritan rules that have been in effect for a long time. These are people who, for reasons completely unrelated to pursuit of their profession, happen to be in the vicinity of the hospital. The first one, though, it seems to me, is an awful lot different. It could be, Judge Wills proposed a pretty broad very broad extension of immunity.
But I think the problem they're trying to address is so that you don't have groups like my clients who say, you know, we tried to do a good thing and we got sued. So from now on, if we get a call from the emergency room, I'm sorry, I can't help you.
Why shouldn't that, from the patient's perspective, why shouldn't that be left to the contractual arrangements between the physician and the hospital? If I respond to your page, you hold me harmless. The patient has no idea where the physician's coming from. The physician comes in wearing a green scrubs and looks like a doctor to me.
The hospital could certainly contract to have those people there, but the whole idea behind the statute is to encourage doctors who have no legal duty. If my clients had contracted with the hospital to add to their coverage the emergency room, then he would have had a legal duty to go down there. The statute is limited, I believe, by using the word volunteer, to only those physicians who have a legal duty. We had no legal duty. Our contract didn't require us to go there, so he's a volunteer. The legislature's made it clear that they want to encourage healthcare practitioners to provide necessary emergency care.
It seems it really opens it up to a hospital contracting with physicians and saying, okay, you are contracted to be on call for OR, and we're not contracting any specialists to be on call for the emergency room. Because that way we get away around the liability there.
I don't know why a hospital would want to do that, because what happens is, just as in this case, wasn't part of the trial, but the hospital got sued for not having ENT coverage available in that emergency room.
I'm sure that happens.
So if the hospital decides to start contracting around and making sure there isn't adequate people to cover its ER, they're going to get sued. And so it might benefit the physician, it certainly doesn't benefit the hospital. So I don't see the encouragement that would occur there in taking the instruction advocated by my opponent. In regards to the issue concerning whether or not the evidence at trial was sufficient under the definition of willful and wanton, I'd like to talk about that for a moment. What the judge said, and we only heard part of what he said, and I would also point out, this was the definition that was argued by opposing counsel to the judge, not me. He was the one that suggested this definition to the judge. And the judge said, what we're doing is giving this doctor the highest degree of protection that they can, short of requiring an intent to injure or kill somebody. Standards required for showing willful and wanton misconduct to be a higher standard requiring a showing of negligence approaching that required for voluntary manslaughter. Basically, just outrageous conduct that would shock the conscience. Now, what the jury heard here was the first reaction of Dr. Augustine, the ER doctor, when he saw this patient was, he needs an ENT. He needs to have a tracheotomy put in. No ENT. Let's find out if we can transfer him. In the meantime, I'll see if I can get an anesthesiologist to help and if they have anything to offer. Dr. Soha comes down, and contrary to portrayal made, it was an emergent, not an emergency. There's a difference. Emergent means you have a serious, sudden medical condition that could turn into a life, or is life-threatening, but it's not like cardiac arrest. It's not a code. In this hospital, if you were on call, which he wasn't, but if he was on call, the time for responding to an emergent situation is 30 minutes. Now, we don't know exactly how long he took. It could have been as little as 10 minutes. It might have been as much as 20, because nobody knows exactly when this call ended and when exactly he got in the emergency room, but he certainly got there a lot quicker than he would have been required if he had been on call. Now, when he gets there, the testimony was Dr. Soha said, this patient, if I try to intubate him, I'll kill him. And Dr. Augustine agreed. And Dr. Lucy, the other ER doctor, agreed. And Dr. Murphy, who they rely on, his sole testimony that they use is a label. He does say the conduct was preposterous. But what else does he say? Well, on cross-examination, he was impeached, and he admitted that 90% of nasal intubations where you're not on a blood thinner like Plavix result in bleeding. In this case, because the patient was on Plavix, it was even higher. If this patient, because his airway was so swollen, if this patient started bleeding, you'd have to abort the procedure, and it would force your hand on a surgical intervention. And because there was no NTE, the only intervention that could be done was a cricoid-thoracotomy, an extremely dangerous procedure that is done only as a last resort, and no one has a great deal of experience in it. Dr. Murphy testified to that. Dr. Murphy testified that it was reasonable for Dr. Soha to be concerned about trying to intubate this patient. He even testified that he didn't know if it was technically possible to intubate this patient. He testified that it was reasonable for Dr. Soha to worry about not making matters worse on this patient. He also went on to testify that you would not want to do anything that could cause this patient to cough or gag, because that would close their airway off. In fact, that's what actually happened to Mr. Harris. And that if you attempted a nasal intubation and they bled, the patient would most likely cough or gag and your hand would be forced. The most telling of what Dr. Murphy was really saying came at the end when counsel got up for redirect, and he asked the sole question of, you admitted that it was reasonable for Dr. Soha to be concerned. What's your opinion about whether or not it would have been successful? And Dr. Murphy said, it wasn't Dr. Soha. He's saying if Dr. Soha had attempted an intubation, then Dr. Augustine could have successfully done a cricoid thoracotomy and saved the patient. He also testified that he believed Dr. Augustine should have done a cricoid thoracotomy anyway, even though we declined to try an intubation. And that if he'd done that, the patient would be alive today. Not only did they not prove that Dr. Soha's conduct was shocking, and by the way, where they portray it that he wants to leave right away, all the evidence in the case was that he stayed there for over 40 minutes with that patient, and he only left when the helicopter landed on the roof of the hospital to take them across the river to Baptist. And then he told Dr. Augustine, here's my beeper number. If you need me, I will come back. And in fact, he did come back when a code was called on this patient. So there was no evidence before this jury whatsoever that a reasonable jury could find that his conduct was approaching that required for voluntary manslaughter. In fact, it's just the opposite. This is a doctor who was acting.
Thank you, Mr. Shipman. Your time is running.
I guess what the court has to decide is whether we've got to prove that he came in blind, drunk, and he was an obstetrician and he performed orthopedic surgery, because that sounds to me like what we've got to prove. Here's what we did prove, and sure, Dr. Murphy admitted there were risks, but here's what he said and we have to go on medical expert testimony, and we have to assume this testimony is true for directed verdict purposes. Patient has a 90% chance of obstructing and dying and could do so at any point. Anesthesiologists should know that. Intubation has a 60 to 70% chance of success. Intubation alone. Intubation with the ER doctor standing by to perform the cricothyrotomy, which is the puncture in the throat, has a 95% chance of success. This is like, would we be here if Dr. Soha were a surgeon and had been called to clamp a bleeding artery, and the patient is spurting blood, and he says, well, there are risks to clamping a bleeding artery. I don't think I'll do it. Would we be here? Yet this is exactly the analysis that our experts' testimony supports. This is a patient who is almost surely going to die. There is a procedure that anesthesiologists are good at and know how to do that will save him.
You're in essence saying that the testimony given to light most favorable to you raises a jury question on this point, and that is that no reasonable anesthesiologist, having weighed the risk, would have failed to intubate this patient. Is that what you're saying?
And that no reasonable anesthesiologist would have failed to appreciate that that was going to kill the patient, and that we can't have testimony about what Dr. Soha thought. I mean, we're never going to get him to say it. How can we prove it?
Well, if it's willful and wanton, though, that does, there are cases that talk about knowing willful.
Well, it's not intending to hurt the patient, though. It's knowing that there's a high degree of danger, and there's knowing that there's something you can do and not doing it. That to me is willfulness. And if otherwise, we really do have to prove an intentional tort, and this might as well be an immunity.
Okay, thank you. Your time is running.